appeal in the matter of the public institutions, social security, and Al-Rajaan and others.
Yes, Mr. Beard, through you, can I just express our appreciation for the cooperation that you've all shown with the difficulties this morning. Thanks to my lady, we've now been able to provide you with a full court, but we appreciate that it will have been some inconvenience. We're grateful.
Oh, well, I'm most grateful to the court and indeed to my lady for stepping in order that this can go ahead, and also grateful to the court for sitting early tomorrow and Wednesday. And there has been a discussion about amending timetable and so on.
Well, we've seen a very sensible looking revision, and thank you for that also. And
before I start, I think on behalf of all those in court to wish Lord Justice Phillips well, send our best wishes to him, please.
Yes, well, we will pass that on.
I'm most grateful. I don't know if you have introductions or a schedule of counsel attending.
We have. I don't think we have our list of those attending and those who are attending virtually, and I don't think you need to spend time introducing everybody. We also have an idea of the running order once we pass your own submissions, but that won't be today.
No, it will not be today. Thank you. Now, in relation to this appeal, which we say raises a series of important points of law, I won't spend too much time setting out the background, which you'll have seen from the judgment and papers. Some of the court may have had opportunity to read, others may have had rather briefer time to grapple with. The claim, as you know, is brought by the Public Institution for Social Security in Kuwait, which is known by the acronym PIFS. It is the institution responsible for providing employment and social security welfare payments to the least fortunate in Kuwait. And I'm sure the court is also well aware that the claims in this case concern claims in particular against the former director of PIFS, Mr. Al-Rajaan, who's the first defendant in the proceedings, and his wife, Ms. Al-Rajaan, the second defendant, and their associates in relation to the payment of secret commissions and the arrangement of laundering of secret commissions. As I'm sure the court is also well aware, the claims against Mr. Al-Rajaan and Ms. Al-Rajaan and the majority of defendants, including many of their associates and various major investment funds who are alleged to have paid secret commissions, will be heard in London, 22 of the 37 active defendants. So the core of the claims to recover the money in question, which amounts to hundreds of millions of dollars, will be heard in London. The spider at the centre of the web is in London, and London will be a place where relevant issues about secret commissions and laundering will be heard. The question on this appeal is whether two banks, Mirabeau and Pictet, who it is alleged paid secret commissions and also engaged in wide-ranging money laundering, and various individuals associated with them, can also be sued in London in relation to the same monies which are also being claimed against, amongst others, defendants 1 and 2.
Mr. Beard, can I just ask whether, sorry, is real-time working? Not yet. It's not me.
No, I'm sorry, I didn't notice. And
not at all.
I don't know.
Could I just ask you for some labelling?
Yes.
So that we can keep track of when you're all making submissions about what particular part of the case we're talking about. As I understand it, there are three elements. One concerns bribes or commissions paid directly by respondents to the lead defendant. One concerns, we might call that A. One concerns the laundering of those monies. One might call that B. And then one concerns the much larger sums, by which it's said that the respondents laundered other people's monies. Now, if it helps, and it would certainly help us to keep track of what you're talking about, if we refer to those as A, B, and C, would that be a reasonable shorthand?
That is entirely acceptable to us. Absolutely.
Particularly because sometimes the descriptions of ancillary matters and laundering and so forth can otherwise get a little blurred.
Yes. So in the taxonomy that your lordship's setting out, B and C are accessory.
So A is bribery claims.
Secret commissions, yes.
B is Pictet Mirabeau accessory
yes.
claims. C is further accessory,
Absolutely.
wider accessory claims.
Absolutely.
That's very helpful, thank you.
Thank you. Yes. Now, in relation to what we're dealing with in this appeal, what we've seen is in relation to A, B, and C, in the terminology we're using, that the judge below, applying the Lugano Convention primarily, but also the Brussels regulation in relation to Pictet Europe in particular, essentially enabled the banks and their associates not to have any of the matters dealt with in London to avoid jurisdiction. Now, the court was provided with a list of issues on Friday. I don't know if I don't think it's gone formally into the bundles, but I think it may be useful just at this moment to have it to hand. Precise formulation of a couple of the issues is a matter of discussion. I'll ask.
I'm very grateful, thank you.
Do you mind if I approach?
Not at all, of course. Thank you.
That's very kind, thank you so much.
The way I was intending to deal with matters in my submissions was to focus first on issue 2, which is what is known as the material validity question in relation to Article 23 Lugano. I'll use Lugano numbering. The submission should be taken as also applying in relation to Brussels regulation. That applies to both the banks. The first issue to do with formal validity is concerned only with Pictet and whether or not certain formalities under Article 23 were complied with prior to 2012. So I'll come back to that. I'm going to start with issue 2. I'll touch then afterwards on issue 3. So issue 2 is primarily concerned with A in your Lordship's taxonomy, but also will pick up B. It is not concerned with C.
Which is why I wondered, why do you have 2122B? Doesn't. Which refers to the laundering of other secret commissions not paid by the banks. That's further accessory claim.
That's because of the respondent notice issue.
Right.
Because the respondents argue that all of C should also be covered by the exclusive jurisdiction.
I understand. So this is a combination of grounds 3 to 5 and the respondent's notice.
Essentially,
but you're
yes.
not dealing. You say you're not going to deal with the rest.
Well, I'll deal with that very briefly and then deal with further points in relation to it in reply. But the focus of my submissions on Article 23 will deal with A and B, and then A fortiori C, effectively. I'll then briefly deal with issue 3, and then I'll go on and deal with issue 4.
And issue 3 is also a respondent's notice point.
Essentially, yes, that's right. And then issue 4 is the question of the application of Article 6, in particular in relation to category C, which is in relation to the money laundering claims. And just, I think, your Lordship has already indicated in your Ladyship a sense of the nature and scale of these differences. If I may, could I just take you to Core Volume 4, tab 41. It's our supplementary skeleton argument.
And once we do that, the point you're about to make is the big difference in size. The money's in the further accessory claims.
There's a lot of money in the further accessory claims, absolutely, yes. And if I could take you to Annex 3 to our supplementary skeleton argument, because it just puts numbers on this.
Page number?
1055.
Thank you.
So you'll see there in Annex 3, and this just makes good the point your Lordship was already making. When we look at the claims against Mirabeau, we have the payment of secret commissions and the laundering thereof amounting to just under $80 million. But then we've got a series of other schemes which do not concern payments by Mirabeau. They concern alleged payments by others.
So it's something like we're concerned directly here with 2 schemes, and there are 7 in all, or something.
Yes,
like
that's absolutely right. At the moment, that's the way the pleading is, yes. But you'll see that the lion's share of the claims against Mirabeau are in relation to non-Mirabeau scheme money laundering. And that is also true in relation to the Pictet banks, which you'll see in the table below, where the payment of secret commissions and the laundering thereof amounts to just under 27 million, but of a vastly larger sum in relation to money laundering of other schemes. And so that just makes good the point I was making in answer to my ladyship's question about, yes, there's an awful lot of money at stake in relation to the money laundering. There are other issues that flow from that, these Article 6 questions under Issue 4, for instance, whether Pictet Bahamas and Asia would be joined in the London proceedings, but also issues in practice of the sort of evidence that will then be available in the London proceedings from banks in relation to money laundering, in relation to this range of schemes that have been used to leach money from the social security funds. So, having set out the general background, just moving to issue 2,
issue 1 comes in what at the end?
I'll deal with it after issue 4, if I may. I'll do it 2, 3, 4, 1, 5, and 6, if I may.
2, 3, 4, 1, 5, 6.
Yeah.
And if we're moving away from the list of issues, could I just raise one point for people to think about? Not to answer now, but for my part, I don't see that 1.3 is an issue as formulated at all, but I may be missing something. And no doubt we can have some assistance on that later. Don't worry about it now.
Yes, I think this is a point primarily raised by the respondents,
Yes,
that
anyway.
Essentially you can backdate the general business conditions. So uging then directly to issue 2. So this is what has been referred to as the material validity under Article 23 of the Lugano Convention. I'll deal with it in 2 stages, if I may. I'll deal with the case law in relation to the interpretation of Article 23, and then I'll look at the judgment of Mr. Justice Henshaw and explain where it is we say he went wrong in relation to the interpretation and application of the law. So it's probably sensible to start with the provision itself. That's found in Authorities Bundle 5, tab 54 at 1816. Now, I'm sure that the court is well familiar with the fact that the Lugano Convention is very much in the terms of the Brussels Convention and then regulation. The difference being that the Lugano Convention covers the EFTA states rather than merely the European Union member states. This is the version from 2007. You'll see at Article 23 under Section 7, Prorogation of Jurisdiction. If the parties, one or more of whom is domiciled in a state bound by this convention, have agreed that a court or the courts of a state bound by this convention are to have jurisdiction to settle any disputes which have arisen or which may arise in connection with a particular legal relationship, that court or those courts shall have jurisdiction. Such jurisdiction shall be exclusive unless the parties have agreed otherwise. Such an agreement conferring jurisdiction shall be either, and I'll just pick up A, in writing or evidenced in writing, because that's the language that we come back to in relation to issue 1. Just for your notes, the previous the initial incarnation of the Lugano Convention is found in the preceding tab 53 in this bundle, and the relevant page number for the equivalent provision is at 1773. The only reason I mention it is because it has a different article number. It's Article 17 rather than 23 in the earlier version.
Sorry, 1773.
Yes.
In identical terms, it's just
Yes.
because the cases refer to Article 17.
That's the only reason I'm referring to it precisely, milady. The situation is slightly different when we come to Article 6, but... If I could then go to the first of the cases I wanted to refer the court to, that's Authorities Bundle 4, tab 36, and the case begins at 1262.
Yes.
This is the Estasis Salotti case. The judgment of the European Court, so this is a judgment from the 1970s when there was only a single European Court. That begins at 1270, page 1270. And it concerned a situation where a German claimant was bringing a claim in the Landgericht Comm against an Italian entity. And it was one of the earlier cases where considerations of the conventions arose. This is, I say, is in fact in relation to the Brussels Convention, but it makes no difference for the purposes of interpretation. If we could go on a page to 1271, what I want to draw from this case at the moment are some general principles in relation to the interpretation of Article 17 of the Convention. And at paragraph 6, it rehearses the text I've just taken you to. And then if we could go to paragraph 7, the way in which that provision, so that's Article 17, is to be applied must be interpreted in the light of the effect of the conferment of jurisdiction by consent, which is to exclude both the jurisdiction determined by the general principle laid down in Article 2 and the special jurisdictions provided for in Articles 5 and 6 of the Convention. Now, Article 2 is the provision that provides that someone can be sued in their place of domicile, which will be referred to on a number of occasions. Special jurisdictions in 5 and 6 concern the place where damage occurs. And then Article 6, of course, is the provision that we will be coming back to about the joinder of other defendants, where one of the defendants is domiciled in a member state. And so what it's saying is that Article 17 can override those provisions, but having regard to the conferment of jurisdiction by consent, in view of the consequences that such an option may have on the position of the parties to the action, the requirements set out in Article 17 governing the validity of clauses conferring jurisdiction must be strictly construed. And so it is sending out a very clear message in this early case law about how it is one construes Article 17 and later Article 23. It is strict construction as an exception to the rules set out in Article 2 and the special jurisdictions in 5 and 6. By making such validity subject to the existence of an agreement between the parties, Article 17 imposes on the court before which the matter is brought the duty of examining first whether the clause conferring jurisdiction upon it was in fact the subject of a consensus between the parties, which must be clearly and precisely demonstrated. So it's drawing on this notion of consent, but it is emphasising that from the point of view of European law interpreting these conventions, the notion of consensus between the party being clearly and precisely demonstrated is important in order to fall within Article 17, Article 23 at all. The purpose of the formal requirements imposed by Article 17 is to ensure that the consensus between the parties is in fact established. And then it goes on to say the questions referred to the court by the Bundesgerichtshof must be examined in the light of these considerations. And I'll be coming back to this case in relation to issue 1. But that's what I wanted to draw the court's attention to in relation to this heading in the judgment about the general approach to our interpretation of Article 17 and Article 23. The next case I want to go on to is at tab 39 in this bundle, beginning at page 1310. This is the Powell-Dufferin case. The judgment of the court begins at page 1334. And the case itself concerned articles of association forming a German company which contained what was referred to as a forum clause, an exclusive jurisdiction clause, in favour of Germany. And certain shareholders, in particular Powell-Dufferin, were suggesting that the forum clause didn't apply in relation to a claim made by the administrator of the German company in relation to payments for shares. The broad history is outlined in paragraphs 2 and 3 of the judgment. And then this is a preliminary reference, so certain questions were referred, which one can see at paragraph 4, for clarification, as to how one interpreted the relevant terms of Article 17 and the relevant provisions of the forum clause. If we could just turn on then to the consideration of the first question, which begins on 1336. You'll see paragraph 6, reiteration of the terms of Article 17, and then 7, it's necessary to determine whether a jurisdiction clause included in Articles of Association of a limited company is an agreement within the meaning of Article 17 between company and shareholders, and then the contentions of the parties set out in 8 and 9, and picking it up at 10. In this connection, it appears from a comparison of the different legal systems of the contracting states that the relationship between a limited company and its shareholders is not always classified in the same way. In certain legal systems, the relationship is described as contractual. In others, it's classified as institutional, regulatory, or sui generis. Therefore, the question arises whether the phrase agreement conferring jurisdiction in Article 17 should be interpreted independently or should be deemed to refer to the internal law of one or other of the states concerned. And then what we see if we go over the page to 14 is an answer being given to that question. The reasoning set out in 12 and 13. Therefore, and as the court has ruled on similar grounds in relation to the words matters relating to a contract in other terms in Article 5 of the Convention, serving as criteria for determining a special jurisdiction, the concept of an agreement conferring jurisdiction in Article 17 should be regarded as an independent concept. And the reason that, of course, is important is that we're not then, therefore, drawing on concepts of domestic law. We are looking at an autonomous European concept. I won't say EU concept, because, of course, we're dealing here with EFTA as well as the European Union, but a distinctly European law approach to these issues. And then it goes on and considers the questions about the shareholder agreement. And if we move then on to the second question, part 1, which begins on 1338. In the first part of the second question, the National Court asks in essence how a jurisdiction clause in the Articles of Association of a company fulfills the formal conditions laid down in Article 17. So there it's looking at the requirements in writing and so on. And then it goes on over the page at 1339 at 30. Second question, second part. Under Article 17 of the Judgments Convention, jurisdictions conferred for the purpose of settling disputes which have arisen or which may arise in connection with a particular legal relationship. This requirement aims to limit the effect of an agreement conferring jurisdiction to disputes originating from the legal relationship in connection with which the agreement was concluded. It seeks to prevent a party from being surprised by the referral to a specified court of all disputes which may arise in the relationships which it has with the other party and which may originate in relationships other than that in connection with which the agreement conferring jurisdiction was concluded. So its emphasis, in line with that strict construction admonition in estasis, is that it is limiting the effect. These requirements are limiting the effect of agreements, and they are focusing on ensuring that you are only concerned with disputes originating from that particular legal relationship. And then it goes on to say, on this point, a jurisdiction clause appearing in the Articles of Association of the company fulfills this requirement where it covers disputes which have arisen or which may arise in connection with the relationships between the company and its shareholders as such. Now that, of course, is not hugely surprising in context, given that this was to do with payments for shares that was the dispute in question in this situation. Now I should say this case has two versions in the bundle, and this version I've taken you to is the one that the judge below was referred to. Just to confirm, the official report from the ECR is in the next tab. And if I may, I'll just take you to paragraph 30 and 31 in that, which is at page 1364. So this again is the second part of the second question. And the key paragraph is 31. That requirement is intended to limit the scope of an agreement conferring jurisdiction solely to disputes which arise from the legal relationship in connection with the agreement with which the agreement was entered into. Its purpose is to avoid a party being taken by surprise by the assignment of jurisdiction to a given forum as regards all disputes which may arise out of its relationship with the other party to the contract and stem from a relationship other than that in connection with which the agreement conferring jurisdiction is made. Now, the difference in language is that in the version I showed you, it talks about limitations on disputes originating from the particular legal relationship. Here it talks about solely being restricted solely to disputes which arise from the legal relationship, and then it refers to the term stem from a relationship. Now, we don't say that anything material turns on those different translations, essentially, but we thought it was appropriate that the court saw the official translation in relation to it. The overall submission is absolutely the same. This is all in line with the strict construction approach that is set out in estasis. With that, if we may turn then to Authorities Bundle 5 at tab 48, 1646. I'm sorry, I should start the case off properly. It's 1603 is the start of the case, the report. Now this is a case heard in the Court of Justice. Again, it's a preliminary reference case. It was a preliminary reference being made in relation to cartel damages claims being brought in Germany. And it concerned claims being brought against the hydrogen peroxide cartel. Now, I'm conscious that at least two members of this court last week were enjoying the pleasures of dealing with particular aspects of competition damages claims. You'll therefore be relatively familiar with the nature of the sorts of claims that are brought. One has a cartel, and customers of the particular cartelists may make allegations that they've been overcharged in relation to the supply of goods or services by the cartel members. And what cartel damages claims CDC, which is the claimant in this case, was doing, was essentially gathering by assignment various claims by various customers in order to bring actions against the hydrogen peroxide cartel members. And one of those members of the cartel was a company, a very large chemical company, Evonik Degussa, that was based in Germany. And so what was being said was that they could bring the claim against Evonik Degussa, and that they could then join all of the other chemical companies, most of whom weren't based in Germany. And so there's Article 6 aspects of CDC, but at the moment I'm just going to focus on the issues to do with Article 23, because what was being argued was that various of the chemical companies from whom customers had bought had in their contractual terms jurisdiction clauses. In other words, the purchases you made from the chemical companies were subject to exclusive jurisdiction arrangements. And of course, what was being said by the chemical companies was effectively, look, you're bringing claims against us in relation to overcharges, in relation to supplies of chemicals, hydrogen peroxide, we made to you. Those were supplies being made pursuant to contracts. Those contracts included exclusive jurisdiction clauses. You needed to sue us under those, in accordance with those exclusive jurisdiction clauses. And CDC was arguing before the German courts that that was not the correct approach. And what they were arguing was that, in fact, the essence of the dispute that arose in the case concerned the relationships between the chemical companies. In other words, between whomever a customer bought from and third parties. And that it was that cartel arrangement that gave rise to effectively a tortious claim that they had then been overcharged in relation to supplies made to them. But obviously there were multiple claims being gathered by CDC. The judgment begins on page 1646. And you'll see the outline of the request for preliminary ruling in paragraphs 1 and 2. You'll then see at paragraph 3, although I haven't taken you yet to it, there is set out there the preamble to the Brussels regulation, which sets out the concerns that are provided for in the recitals to that regulation, as to why it is one has the sorts of rules in relation to jurisdiction then set out in the regulation. And in particular, it talks about, in recital 2, the differences that exist between national rules and the desire to unify these rules. In 11, particularly, the importance of having a highly predictable regime and founded on the principle that jurisdiction is generally based on the defendant's domicile, and jurisdiction must always be available on this ground, save in a few well-defined situations. And then in 12, in addition to the defendant's domicile, there should be on alternative grounds of jurisdiction based on a close link between that court, the court and the action, or in order to facilitate the sound administration of justice. So that's very much more Article 6. And then 14, the autonomy of the parties to a contract other than insurance must be respected, subject to the exclusive grounds of jurisdiction laid down in this regulation. So that's very much directed at Article 23 that we're concerned with now. 15, in the interest of harmonious administration of justice, it's necessary to minimise the possibility of concurrent proceedings and to ensure that irreconcilable judgments will not be given in two member states. And as we'll come on to see, that desire to avoid fragmentation exists within the Lugano and Brussels scheme, but it is inevitably not eliminated because you do have these systems of exception. If we go over the page, what I've broadly tried to summarise in opening on this case is set out in paragraphs 9 and 10. But then in paragraph 12, one sees that there was a wrinkle in this case. That in September 2009, CDC actually withdrew its action against Evonik Degussa following a settlement with that undertaking. So that it brought the claims in Germany using that as the anchor defendant, but then subsequently withdrawn that. You'll see at 14 the questions that were set out. The first is to do with 6.1 that I'll come back to when we deal with issue 4. The second's in relation to Article 5, and it's the third we're interested in at the moment. In the case of actions for damages for infringement of the prohibition of agreements, decisions or concerted practices contained in Article 81 EC, now Article 101 of the TFEU, and Article 53 of the EEA Agreement, does the requirement of effective enforcement of the prohibition of agreements, decisions and concerted practices allow account to be taken of arbitration and jurisdiction clauses contained in contracts for the supply of goods, where this has the effect of excluding the jurisdiction of a court with international jurisdiction under 5.3 or 6.1. So that was the third question that was being posed. And if we pick up the answer to the third question, you'll see it starts at page 1656. And I won't go through the preambular paragraphs. If we go over the page to 1657. Because it's talking about here how Article 23 can operate. And then it says, in a case such as that in the main proceedings, the court before which the action is brought must nevertheless ensure that the clauses at issue actually bind the applicant before examining the requirements of form laid down in Article 23. As the court has already made clear, a jurisdiction clause incorporated in a contract may, in principle, produce effect only in the relations between the parties who have given their agreement to the conclusion of that contract. In order for a third party to rely on such a clause, it is in principle necessary that the third party give his consent, and that's a reference to a case called Comm, which is actually in the preceding tab in this bundle. And then if we go down to 66, if the applicant did prove to be bound by the clauses at issue, it will be necessary to ascertain whether they did in fact derogate from the referring court's jurisdiction as far as the case in the main proceedings is concerned. In that regard, it's for the national court to interpret the clause conferring jurisdiction invoked before it in order to determine which disputes fall within its scope. And so we've got the citation of Pal Duffer in there. A jurisdiction clause can concern only disputes which have arisen or may arise in connection with a particular legal relationship, which limits the scope of an agreement conferring jurisdiction solely to disputes which arise from the legal relationship in connection with which the agreement was entered into. So here we're having the language of the previous case law repeated. The purpose of that requirement is to avoid a party being taken by surprise by the assignment of jurisdiction to a given forum.
We've had that, haven't we? So we've had this already from the previous case.
And in the light of that purpose at 69, the referring court must in particular regard a clause which abstractly refers to all disputes arising from contractual relationships as not extending to a dispute relating to tortious liability that one party allegedly incurred as a result of the other's participation in an unlawful cartel. So, if I just go on to 70 and 71, given that the undertaking which suffered the loss could not reasonably foresee such litigation at the time it agreed to the jurisdiction clause, and that the undertaking had no knowledge of the unlawful cartel at that time, such litigation cannot be regarded as stemming from a contractual relationship. Such a clause would not, therefore, have validly derogated from the referring court's jurisdiction. By contrast, where a clause refers to disputes in connection with liability incurred as a result of an infringement of competition law and designates the courts of a member state other than the member state of the referring court the latter ought to decline its own jurisdiction, even where that clause entails disregarding special rules of jurisdiction. And so, in consequence, the conclusion of the court is that even when you are dealing with a very broadly phrased exclusive jurisdiction clause, because of the approach that is set out in European law to the interpretation of those clauses in circumstances where there is an importance on informed consensus not being taken by surprise, in circumstances where one is dealing with strict construction, it said that those exclusive jurisdiction clauses in the contracts did not pertain to the cartel damages claims that were being brought by the customers. And we say that is fundamentally important to the way that one should look at the jurisdiction clauses in this case. Because one can immediately see the analogy in relation to the secret commissions we're talking about in this case. The secret commissions we're talking about in this case...
So A.
A, yes, sorry.
No, I'm just checking.
A. But I'm dealing with A as the paradigm for these purposes. Right. Whatever applies to A will undoubtedly apply to B and C as well. But in relation to A, the secret commissions are flowing either from banks to third parties through conduits of various sorts. In other words, the claims that are being made in relation to the secret commissions are claims concerning the tortious civil liability, or indeed under Q80 law, also potential criminal liability, involving the banks and third parties. Now, it is, of course, right that we are suing both the banks and the third parties, but for the purpose of analysing the jurisdiction clause, the argument that is being put by the banks, that by opening accounts with them, we thereby entered into jurisdiction clauses that govern disputes arising out of relationships between the banks and third parties, is simply not a tenable reading under European law of the relevant jurisdiction clauses. And that is what CDC is saying in terms, effectively. And it's worth bearing in mind, particularly when we think about the Mirabeau situation, the majority, in fact, of the investments in relation to which secret commissions were paid by Mirabeau didn't pass through and were not held in the bank accounts, or the bank account in the case of Mirabeau, which is said to include the exclusive jurisdiction clause, which somehow has the pull on all of the disputes in relation to secret commissions that we raise in relation to it. Now, we recognise in relation to Pictet, there were many, many more bank accounts opened, but we say the principle still applies.
Sorry, so there was only one account, was there, with Mirabeau?
Yeah, account 500,750 is the number that is referred to. And only 11 of the 28 investments in relation to which secret commissions were paid actually went through or were held in that account. And so we say, what CDC is telling us is that we have to adopt a narrow approach to the interpretation of material validity, European law scope of the relevant jurisdiction clause for the purposes of applying Article 23. And we say the analogy with the situation of third parties entering into a cartel, one of whom supplies you as a customer, is a relevant and close analogy. And what we'll see when we come to the judgment is, frankly, the judge simply did not engage with the importance of this issue when he analysed the law. In fact, what he did was he ended up moving away from this case and becoming distracted by the next two cases that I'm going to take you to, we say do not remotely qualify the analysis in CDC. The next case I'm going to go to is the Apple sales case, which is at tab 52 in this bundle, starting at 1745. If I could just pick it up in the head note, just to give you a little bit of background. What was at issue here was that a French company was a distributor of Apple's products. And the Apple company with whom it had a relationship was actually based in Ireland. It's called Apple Sales International. And the complaint by the distributor was that it had a contract to distribute Apple products, but Apple was, contrary to what is Article 102, which is the prohibition on abuse of dominance. So this isn't about cartels, this is about monopolies, essentially. What they were alleging was Apple's a monopoly, and we're a distributor of your monopoly products, and you are not dealing with us fairly under the terms of our distribution agreement. And that amounted to an abuse of dominance. And it's a French company that is making this complaint. And Apple is saying, and that brings the claim in French courts, and Apple is saying, well, hang on a minute, we've got an exclusive jurisdiction clause under this distribution agreement for this matter to be litigated in Ireland. Now, in relation to this case, I am just going to briefly pick up the opinion of Advocate General Val, as he then was. He's now in the upper court, but at the time he was an Advocate General dealing with these issues. His opinion begins on 1747. And if I could just pick it up at paragraph 10, 1749, you see that he summarises, broadly speaking, at 10, the articulation of the concern by the French company. And then you'll see in relation to paragraph 11, the terms of the relevant jurisdiction clause that was at issue. His analysis then begins at paragraph 21, page 1751. And he highlights the fact in paragraph 24 and 25 that the Cour de Cassation in France had considered that it was only if the clause in question was expressly covering competition claims that it could be said to apply to the claims that were being brought by MJA in this case. And a court in Portugal had thought somewhat differently. And you'll then see over the page at 30 his emphasis on the importance of strict construction, and references in 31 to the Powell Dufferin and cartel damages case. The reason I just mentioned these references is because when we come to it, the judge says that somehow the court here was distinguishing cartel damages. Neither the Advocate General nor the court were distinguishing them, cartel damages, at all. It was applying the basic rules to a different situation. Then you'll see over the page that he considers the examination of these issues. First of all, at 34, he emphasises the primacy afforded to the autonomy of the parties, as expressed in the validly agreed jurisdiction clauses. So he's recognising party autonomy there, as indeed the Lugano Convention does. Then he says at 36, the binding force of the clause means next that it's not required that the court designated by the clause have any link of proximity with the dispute. So you can choose whatever court it is that you want under your jurisdiction clause. There isn't a further test. And he says that asymmetry of clauses doesn't matter in 37. Then he goes on at 40 onwards to consider the first question that was posed on the preliminary reference about the applicability of a jurisdiction clause in the context of an action for damages brought by a distributor against its supplier on the basis of 102. And he says, in essence, it can't be assumed that it applies to Article 102, but there's no inherent obstacle just because of the nature of 102. And if we go over the page to 2 pages to 1755, pick up the second question, there he's dealing with the question of the requirement for an express reference to disputes relating to liability incurred as a result of infringement of competition law. And in particular, at 58, he highlights the solutions that he's proposing would be an extension of the position that gave rise. I'm sorry.
But paragraphs 56 and 57 are important.
Yes, but yes, if we pick it up at 56 and 57, to my mind, it would be disproportionate.
Shall we read those to us?
Yes, please, and through to 58.
Thank you. Right, so that conclusion refers to what? This conclusion or the...
Yeah, that conclusion is referring to the preceding paragraphs to which my Lady Justice Carr referred to. And then he goes on in 62 and 63 to talk about CDC in the context of CDC. Through into 64. And I know my learned friends place weight on these paragraphs, so I direct you to them.
Thank you. We'll read those. Well, you yourself presumably are relying on 64.
Yes, but actually I then go on, if we may, to 66. I do rely on 64, but I think it's just important to keep working through. Because in 66 what you'll see is an explicit recognition of the importance of the reasoning in CDC in paragraph 70.
Yes.
And so what he's saying is that actually it matters what sort of conduct you're dealing with. And you can see this explicitly actually in 68. Because what he says in 68, the thinking of the Advocate General is, well, yeah, in CDC, what you had was essentially a claim against the cartelists. But if what you were dealing with under Article 101 was agreements between suppliers and distributors, then it might be you'd have a different result in relation to matters. In other words, he's saying it doesn't matter whether it's 101 or 102. What you have to look at is the nature of the dispute that you're dealing with. And in CDC, you were dealing with a dispute relating to the interaction between the third-party cartelists, including one of the persons against whom you, as a claimant, would bring a claim. And then he concludes in relation to this case that here, what one should find is that actually the jurisdiction clause that applied in this case would cover the abuse in question, because, of course, the abuse in question was an abuse being alleged against the co-contractor in relation to the way in which they dealt with the distributor. So, before I just move on to the judgment, I'm just finishing up on paragraph 77 over the page on 1758.
Yeah.
This is not a case distinguishing CDC. What it is doing is applying the rationale of CDC in the light of the admonitions as to how one interprets these clauses, given Estasis and Powell-Dufferin and the prior case law. It is not remotely saying that CDC is wrong or has to be qualified. That's not what he's saying. He's recognising that where you've got a tort claim relating to the conduct of cartellists, it may well be right, and indeed is right and binding under CDC, that one doesn't treat a jurisdiction clause.
I don't remember the judge saying that CDC was wrong, or
No,
that
he
it needs to be
distinguishes it.
qualified.
No, he says it's distinguished by Apple sales. I'll come back to that. But the point is he focuses on Apple sales, and as I'll come on to, he focuses on this notion of the conduct materialising. But what I want to emphasise in relation to Apple sales is that what you have from the Advocate General is a detailed account of how one has to focus on where is the tortious dispute arising vis-à-vis the jurisdiction clause. And where you have, as in this case, an abuse being alleged against the counterparty to the contract in respect of the terms with which it dealt with the distributor, he says, well, that makes sense and that fits with the approach that has previously been set out. And then if we go to the court's judgment itself at 1762, the consideration of the issues begin at 1766, and in somewhat typical fashion, the court is much more terse than the Advocate General in relation to its treatment of these issues. You'll see in paragraphs 21 through to 24, in fact down to 25, that essentially, I won't read it out because it's essentially just repeating CDC and the relevant paragraphs I took you to in relation to CDC. I would just emphasise in relation to paragraph 24, what it's stressing is that in relation to the conduct that was concerned in CDC, where it was not reasonably foreseeable for the counterparty, in those circumstances, the jurisdiction clause could not be said to apply given the importance of the principles of consensus and no surprise. That is being reiterated. And then you'll see that having drawn on those provisions of CDC, you'll see at 26, in the light of that case law, it's appropriate to examine whether the interpretation of 23 and the grounds on which it's based are also valid in regard to a jurisdiction clause invoked during a dispute relates to tortious liability incurred by one contracting party as a result of a breach of 102. That is the case where the alleged anti-competitive conduct has no connection with the contractual relationship in the context of which the jurisdiction...
Sorry, where are you?
I'm going from 26 to 27. And then you see at 28, this is perhaps the key paragraph, how while the anti-competitive conduct covered by Article 101 FEU, namely an unlawful cartel, is in principle not directly linked to the contractual relationship between a member of that cartel and a third party which is affected by the cartel, the anti-competitive conduct covered by Article 102, namely the abuse of dominant position, can materialise in contractual relations that an undertaking in a dominant position establishes and by means of contractual terms. And I've just emphasised the term materialises because it figures large in the judge's judgment. But whilst it's, and I'd invite you to read paragraphs 29 and 30, if I may. But all that's being said here is that you have to look at the nature of the claim that's being brought, the dispute, whether or not it's arising from the relationship, the particular legal relationship, in relation to which the jurisdiction clause has been entered into. And here, it can be said, yes, it does. And the term materialises is just being used in that context because what you have is an abuse by a supplier in relation to its distributor that can amount to an abuse of dominant position. And so whether you treat it as a contractual claim or a tortious claim, it's still arising from that vertical relationship. But it is in no way qualifying the analysis in CDC, which says where you have a tortious claim in relation to activities relating to a counterparty to an EGC and third parties, EJC, then in those circumstances, you don't have the sufficient proximity connection, whatever it is that one uses as the term, particularly in circumstances where you have that level of secrecy that means you cannot foresee when you're entering into that sort of jurisdiction clause that that sort of third-party relationship would be governed by it. And that is what the European law is saying in relation to these matters. Now, the final case I want to come on to in relation to this analysis is the Etihad case, which is obviously it's an English case, Justice Jacobs. That's in Authorities Bundle 3, tab 27.
This hasn't gone up on appeal or anything.
No, not as far as I'm aware
My
now.
lady, it has gone on appeal,
But not on this issue.
but not on this.
Yeah.
Forgive me.
Not on the
Not on
relevant
this
point.
particular point.
That's what
So
I had a
The,
recollection of something.
asymmetric jurisdiction point was decided by this court.
Thank you very much.
Thank you. Right. I'd just invite the court just to read their head note just to get some context of the nature of the dispute. So here we have a situation, lender borrower, facility opened, and then a subsequent comfort letter being provided. And obviously it's the facility that contains an exclusive jurisdiction clause, and the question is, does that exclusive jurisdiction clause also cover disputes that might relate in relation to the comfort letter that's subsequently provided? And the discussion of the issue then begins at page 876. Mr. Justice Jacobs considers relevant paragraph 31 of Pal Dufferin to begin with. He says at 125, it's not just a question of whether or not you're being taken by surprise, although that's indicative. He then he considers at 126 the CDC case referred to as hydrogen peroxide and quotes paragraphs from it. And you'll see at 129, he's quite properly not demurring or seeking to qualify anything in CDC. Then at 130 and 131, he says, I don't think the court should take the narrow approach suggested by Mr. Joseph, namely disregarding the commercial background, disregarding the timing of the relevant agreements, focusing only on the language of the claim asserted in German proceedings and the characterisation of a relationship in those proceedings, and comparing it to the contract containing the jurisdiction clause. We're not trying to take such an extreme approach here. And at 131, he says, the test requires identification by reference to the facts of the case as a whole of the legal relationship between the parties in connection with which the jurisdiction agreement was concluded, then requires consideration whether the dispute originates from that relationship or a different one, and we don't demur in relation to that. I touch on 133 only because the judge refers to it, and we'll come to see that in a moment. It's also important to note that the relevant question is whether the dispute has arisen from the legal relationship in connection with which the jurisdiction was concluded. Just invite you to read that
It's described as largely a factual question.
It is described as a factual question, absolutely. There will be factual analysis that's required here, but that factual analysis we don't shy away from. But of course it has to be carried out through the relevant frame or prism of a correct interpretation of the law. And we say that's not been done here.
And he also says what CDC did was to provide an illustration.
Yes. Well, of course, milady, we're not here dealing with a cartel case, of course. And I make the submission by way of close analogy with CDC in terms of the structure. I don't try to pretend that it provides any binding authority, nor could it, because, of course, it's a preliminary reference and therefore is never going to make a final conclusion on factual matters. And then if we go on over the page, all of this is sidelined, and we'll come back to some of it when we look at the judgment. But what we see in 137 is the analysis of the genesis of the comfort letter. And we see that in 137 and 138. So what occurred in this case was a facility being provided by one party to another, including the exclusive jurisdiction clause. Given the debate which then occurred about whether or not there was a willingness to provide further capital, a comfort letter is then provided between the same two parties. And in those circumstances, looking at the overall context, even applying the strict construction approach, one says, well, here we can say that in fact the jurisdiction clause was covering the lender-borrower relationship that was being supported by the comfort letter. And again, we don't have any issue with that. The point is that our situation is very, very different. If we go over the page, the judge sets out a range of reasons, and then 143, he emphasises that notion of surprise and consensus that we've seen in the context of the analysis.
Much of it is common ground, I think, but nobody suggests, do they, that the being taken by surprise is a legal test.
No, absolutely not.
And Mr. Justice Jacobs, yes.
No, he's not remotely saying it's a legal test. He's saying, but I think if one goes back to what he said...
125, I think.
Yeah, 125, precisely, milady. It's not a legal test, no. But it is a relevant it's a relevant point of assessment when one is talking about whether or not you had the relevant consensus, which is emphasised in the case law for the interpretation of Article 23. And then over the page, in paragraphs 148 through to 150, he considers the wider context of the relationship between the parties. And as I say, in doing so, what he emphasises is the background relationship of Air Berlin being funded by the major shareholder who provides the capital and then supports it with a comfort letter. And so we say no issue with the outcome of Etihad or the analysis being carried out by Mr. Justice Jacobs in relation to Etihad, But we say that doesn't cut across anything we say in relation to the proper approach to CDC, Apple sales, or indeed the prior case law, which is indicative of the way in which the European law approach should be adopted. There's one final piece of law I would take you to, which isn't case law. It was put in by the respondents. It's part of the new edition of Professor Briggs's book on jurisdiction and judgments. It's in Authorities Bundle, Volume 6, tab 63. If we could just pick it up at page 2047. This is in the section Scope of the Jurisdiction Agreement. And I don't, this is one to read at leisure perhaps, but he then, over the page at 205, talks about Pal Dufferin, and picking it up at the bottom of page 205. The qualification to that, the analysis of interpreting the wording, must now be noted. In the context of disputes arising from unlawful cartel activity, the European Court ruled that a claim for damages for the infringement of Article 101 may not be found to fall within the terms of jurisdiction agreement, which it's reasonable to suppose was not made with such proceedings in mind. And then he goes on to talk about CDC, and I think the bit that's been highlighted by my learned friends is down at the bottom of 206. It remains to be seen whether this aspect of CDC is an outlier or is the first step on the road towards a set of autonomous rules of construction of jurisdiction agreements. It may be the latter, and then he says, see Apple sales, because the claim, and there he talks about the dominant position situation. And he says that the EU may well be adopting an autonomous account. Now, we would say here that, with respect to the Professor, he's actually not giving credit to what the European authorities have already done. One can say, yes, it is an autonomous account that's already been being given. It's not that just these two cases that have produced it.
Are you interested in footnote 160?
And I was just about to go to footnote 160. Your Lordship is ahead of me. But what the Professor does observe, even though we don't necessarily accept his characterisation of how we got here, is his conclusion that, in fact, if you're looking at this case and you apply the rules in CDC and Apple sales, you would say in relation to this case, so far as he's concerned, and I'm not pretending he's in any way a binding authority on these matters, that precisely this situation is one that you would say is not governed by the jurisdiction clauses with which we're dealing. Now, those are the legal submissions. I'm conscious that there are people...
Would this be a good moment to have... I'm going to call it a 5-minute break, just so everybody shouldn't scatter.
Yes.
And that we keep our momentum going. We will stop for 5 minutes now.
I'm grateful.
Right.
You don't want to go anywhere, do you? Why would I?
You can't move.
Sorry, I know you were.
That works for us.
Got it.
As far as the French Coast plan, A
Yeah. You find your way practically mechanically
It's very useful as a sort of court tool. It's never useful after court.
It's less than useful to make involved. I don't think it's
Let me try and think of an answer that isn't very rude.
okay. Give an example of how long it's been useless.
So, let me think.
I think transcribe. I mean, if the transcribe is what on YouTube.
Yeah.
So
So that's the problem.
the normal one in court. I mean, the whole idea is you transcribe from court. That's why you're getting that kind of complex for that number.
But I'll tell you why less than useful. Because it's taking up space on my
Yeah,
desk.
that's true. That is a good point. So I can't see you because I missed that one.
Well, very good, Richard. Very good.
Yes.
Everything is wildly so we went back about that. Have you ever read that? Wow, clearly we've done.
It's very hard to it's unreadable. Is really it's horrible. I mean, ergonomic. This is about the person it gets. It is. You know, if you want to divide away almost impossible.
Yeah, this would be, as you say, but it's good.
The transcript is just too behind. It takes a part of I don't know when I came on.
Yeah. Oh, absolutely.
Yeah.
Put my feet up on a rail and just watch.
Yeah.
So,
Me choosing.
Well, I mean, actually, it's yeah.
I've got it. Thanks.
oh well.
So you're doing issues 2, 3 and 4. Serial validity. And article 6. Then what? Which makes no sense. Method in madness.
So I mean, actually,
Yeah. We're not going to get to Article 6 until tomorrow. That's a lot to squeeze in, isn't it?
Let's clean it.
Yeah. Yeah. Political issues arise in relation to Maribor, don't arise in relation to
Oh, I'm sorry.
but in truth.
Exactly according to the law.
Thank you. If we could pick up the judgment then at Core Volume 2, Tab 23. I'll pick it up at page 389.
Do you mind referring to paragraph numbers?
Of course.
As well as you go along.
Yes, happily. So picking it up at 187.
Thank you.
So this is the section where the judge deals with the law on material validity and then goes on to talk about how it applies, the European law. And I'll go through, I'm not going to obviously read through it, but I just want to refer to one or two of the paragraphs. After introducing the clauses at 191, he recognises that we're dealing with autonomous European principles. At 192, he refers to Pal Dufferin.
Do you mind telling us in advance whether you're taking issue with any of what's following?
Of course. Yes.
At what point do you begin to take issue?
At what point we begin to take issue? I think in relation to the quotations through here, so through Etihad at 194, CDC is mentioned and quoted at 196. Then we're back to Etihad 197. We're obviously not taking issue with any of those quotations for the reasons I've already articulated. I don't think we take issue with 198, which is an attempt to summarise parts of Mr. Justice Jacobs' analysis in relation to that case, and nor 199, where the judge accepts that it's possible that each contract could give rise to a separate particular legal relationship. I don't think we actually disagree with 200 and 201.
Or the second half of 199.
I'm sorry.
Where it says it does not follow, however, he accepts your submission, but he says, however, a jurisdiction clause in one contract cannot be regarded, it doesn't follow. You accept that?
Yes,
Have regard
but
to the thrust of the claim?
Yeah, we have to accept that because, I mean, that flows from Etihad in particular.
And so 200 is okay as well?
200, I think, yes, 200 is saying you can't have wholly abstract terms, same with 201. Then we're back to Etihad again in relation to Mr. Justice Jacobs. 203 is a purported summary of Etihad.
Forgive me, 201 is okay as well?
I think in broad terms, yes, because what it's talking about are the issues in relation to abstract clauses. What's actually being referred to there is case law that says if a clause is very broadly drawn, then it's not likely to fulfil the requirements of Article 23 because it will be too broadly drawn for there to have been an informed consensus in relation to...
Yes, it doesn't have to be meticulously drawn, but
no.
It can be too broadly drawn.
Yes, exactly. That's what's being said there. And I think that's all, in fairness to the judge, that's really being said in 200 and 201. Then when we get to 204, I'm not actually sure that in relation to 204 we're necessarily saying that anything has gone wrong there. Because when he says in the second sentence, if on its fair reading a jurisdiction clause applies to the legal relationships comprising or forming part of the status relationship to which the parties have referred, then it may be appropriate to construe the clause in that way, provided that, in the light of the clause in question, read in its context to do so, would be consistent with the principles of legal certainty and avoidance of surprise. So again, we don't have an issue there. Actually, what's slightly missing in all of this is a real recognition of that basic principle from S. de Sassolotti of strict construction. So it's what's missing as much as what is said that is important to this point. And then at 205, we do get this funny phraseology where he says the Court of Justice distinguished its decision in cartel damages claims. And we say actually the reasoning in cartel damages claims was then carried over in relation to a different factual situation in relation to Apple sales.
Right, so he says distinguished. If he'd said considered, then we'd be moving on swiftly.
I'd be moving on very swiftly.
Right, so what is the distinction that you
Well,
say he then goes on and draws, or are we just talking about a word?
Well, I'm not going to have a semantic quibble about it. It's because subsequently what he says is that effectively one should apply the materialises test in Apple sales in relation to these matters. That's what he then goes on to emphasise in relation to 206 and 207. And it's particularly there that the problem arises. So actually, the difficulty with the reasoning in relation to the law is it's missing the basic structure of strict construction. It does refer in passing to surprise at the end of 204, but it doesn't focus on these notions of consensus that are so heavily emphasised. It places an awful lot of weight on Etihad, which, as I say, we're not demurring from the conclusions in Etihad, but as an articulation of the code for interpreting Article 23, it is not a substitute for looking at the basic principles that we've been looking at. And so when we come to 206, he emphasises Apple sales makes clear first that there's no need for the jurisdiction clause to make express reference to the particular type of dispute in order for it to be covered, and he refers to Advocate General Vaal. Well, we don't, again, demur from that basic proposition, but you then are having to ask yourself the question, does the disputing question arise from the particular legal relationship? And then it's at 207. Secondly, Apple sales indicates that the EU proximity requirement, insofar as such a requirement appears to exist, and we say, well, look, it plainly exists. That is what all of that case law is talking about. The parenthetical raised eyebrow here is an indictment of the judge misdirecting his approach at this point. Can be satisfied where the events giving rise to...
I think it's maybe, again, without wanting to dance on the head of a pin, maybe it's the requirement. It is the emphasis, not the proximity factor, if you see what I mean.
Yeah.
But anyway,
yeah,
I see the point.
I see your ladyship's reading of it, and I don't want to take it too far, but it can be satisfied where the events giving rise to the dispute can materialise in the contractual relations between the parties. In principle, that requirement could be satisfied in a range of cases. Now, again, there's an extent to which we don't disagree with that proposition. To take two familiar examples, a claim for fraudulent or negligent pre-contractual misrepresentation alleged to have induced a claimant to enter into a contract would relate to events said to have materialised in the parties' contractual relations and thus subject to the scope of the clause, as interpreted under governing law, could fall within the jurisdiction clause under Article 23. Similarly, a claim that a contract has been induced by bribery might well concern events said to have materialised in the parties' contractual relations and could fall within the clause for Article 23. So he's here very much focusing on this concept of materialising, and then he's talking about two very different situations from the ones that we are actually talking about here. He's talking about misrepresentation giving rise to a contract or inducing a contract by bribery. Now, there are two things to raise in relation to this. We now find ourselves referring to Fiona Trust. Now, he is only saying there, to be fair, as was the case in Fiona Trust. But we are in territory where undoubtedly the approach in European law is not in line with the common law, because the structure and framework of approach to interpretation of Article 23 is not simply to be taken as the approach that Lord Hoffman adopted in Fiona Trust. More particularly, he's emphasising here two situations where it is well arguable that they may not fulfil the criteria of Article 23, but they're also just not the subject matter of what we're talking about here. Because if we think about the situation we're dealing with, what we're dealing with is the making of investments by PIFs through banks and with investment houses. None of the claims are trying to avoid those arrangements for the investments. It is not what the claims are about in this case. Indeed, none of the claims are trying to say that somehow the bank account contracts themselves were void. The one with Mirabeau and the 96 with Pictet. Because those are the flows of money into investment houses. And we are not trying to say that those arrangements, which are the contractual arrangements in respect of which the exclusive jurisdiction clauses arise, are somehow void. What we are talking about is the subsequent use of monies, particularly fees, being taken by the director, his wife, and other associates in circumstances where they should not have received those fees. And so what we end up with here is a situation where the judge has missed the significance of the analogy with CDC entirely, because we don't come back to that. He quoted CDC, but there's no analysis of it. He says, as your lordship says, distinguished, maybe it's just considered, but actually he's not focused on the essential analogy. He has focused on this materialized concept, and as we come on to see, by focusing on this notion of materializing, he is in danger of actually running counter to CDC. Because, of course, in relation to CDC and any cartel damages case, one can, of course, see the effects of a cartel, in one sense, being made manifest or materializing in the price you pay as a customer. Of course that occurs. That is what all of these cartel damages cases are predicated on. But CDC plainly says that is not enough. That is not a sufficient connection. So, lacking the analysis of strict construction, failing adequately to take into account the considerations of consensus, although there is a passing reference to surprise, lacking a consideration of the analogy with CDC, which is so important, appearing to say that CDC is distinguished, but I take your lordship's point, maybe it's only considered. But that then sets the framework where he emphasizes this concept of materializing, and therefore has approached the whole analysis of the situation wrongly framing the legal background. Because we have ended up at 208, and that is the end of the legal analysis. And then what we see in the subsequent sections is how this skews the way in which the judge looks at these issues. Because rather than applying the strict approach to what constitutes a particular legal relationship, or is the dispute arising from or originating in that particular legal relationship, he adopts a much broader approach to these issues. Because what he does in the subsequent paragraphs 209 in relation to bank onwards or in relation to Bank Pictet, 220 in relation to Pictet Europe, and then 227 in relation to Bank Mirabeau, is essentially say, well, look, when you opened the bank accounts, the one in relation to Mirabeau in 1997, the first one in relation to Pictet, I think in relation to 1998, what you did was you agreed to exclusive jurisdiction in relation to the matters being dealt with in relation to those bank accounts. And subject to issue 1, those bank accounts referred to the general business conditions, the GBCs, and those included exclusive jurisdiction clauses. And what he then says is, and the general business conditions refer to a whole range of possible interactions between PIFs and the banks. Different versions of them talk about stockbroking arrangements or commodities dealing. But the big emphasis he places on these general business conditions, as one can see, for example, at 211, is saying that once the general business conditions are incorporated into the bank account, it talks about a business relationship between the client and the bank. It talks about a legal relationship between the client and the bank. And then the judge says, and this legal relationship is broad enough to encompass all of the sorts of arrangements that we're talking about, which are the subject of the claims in relation to secret commissions. And we say that just doesn't follow at all. The fact that you have a legal relationship developed through a bank account, which is then subject to general business conditions, doesn't in any way necessitate a broadening of the legal relationship.
Just would you?
I'm
I know
so
we're
sorry.
getting millions of real-time and transcripts, but
I'm so sorry, my lady.
no, it's the fact that you develop a relationship does not necessitate. Can you just fill me in? The fact that you develop
A relationship through a bank account, so it's a bank account through which you pay monies or in which investments are held, does not mean that the legal relationship between you and the bank is much wider for the purposes of Article 23, just because the general business conditions can cover wider relationships.
Is this sort of thing a fact-sensitive assessment? So that, for instance, if I, as a retail customer of a high street bank, sign up to their conditions, then the situation in which they themselves clean out my account is completely beyond contemplation, or at least do so deliberately and dishonestly.
Yes.
There are other sorts of banker-client relationships where expectations might be different, where risk assessments might be otherwise.
Yeah.
So for the moment, I'm not asking you to situate this case against my example, but it isn't good enough, is it, in this situation, just to say, well, a banker-client relationship is such and such. One is looking, isn't one, to form the answer to a particular case, to the particular parties that are involved.
That it must be right. And I must accept that. One has to look at the facts of the particular relationship.
Yes.
What we say has clearly gone wrong here is that when one contemplates how one interprets the nature of a particular relationship and dispute arising from a particular relationship, one must do so narrowly, having regard to consensus. And what we say is, it was not correct to reach a conclusion that claims being brought in relation to secret commissions could sensibly fall within the scope of this relationship arising from the opening of bank accounts, given the rules on the interpretation of Article 23.
Speaking of myself, the most striking aspect of this part of the case is the fact that your clients allege wholesale fraud by their bankers on themselves.
Yes.
Is 207, which you took us to a moment ago, is this the part of the judgment where the judge most nearly engages with with that issue? Or can you remind me, does he go on elsewhere to say something about it?
Well, we've got two parts of the judgment I was going to go to. I've briefly referred to what he's doing in relation to 209 through to 232, which is this emphasis on the general business conditions. But he does also...
And your submission there was what? That it was the fact that you develop a relationship through bank accounts does not... No.
Yes, the fact that a bank account relationship also refers to general business conditions, doesn't expand the nature of the particular legal relationship, and certainly doesn't expand it to the extent of covering what your lordship referred to as wholesale fraud in relation to the bankers.
But doesn't that depend on an analysis of the facts? You're not limited to the contract, you're looking at the legal relationship. And isn't it an evaluative assessment, and it may encompass fraud depending on the facts, or it may not?
It may, in certain circumstances, encompass fraud, but in order to interpret whether or not those clauses do encompass fraud, you have to approach it using the strict construction interpretation that is the requirement under European law. And so what we're saying, and the reason I've spent time in relation to the legal issues, is because it is plain that that strict construction application and the need for the consideration of consensus that is emphasised is missing from the judge's analysis, and he then carries that over when he considers the particular facts of the case. And that is why we say, yes, there can be a spectrum of situations depending on the facts, but this is a wrong analysis because it has started from the wrong starting point in relation to the legal analysis. And he just doesn't...
the judge's approach is to be picked up not just from his self-direction, which you've taken us now through completely, but also from the manner in which he approaches the individual defendants.
Yes.
Were you going in a moment just to show us another place where he
Yes,
addresses
I
the
was,
point that
because
was
I don't want to be... The judgment is slightly odd in the sense that the section I've been stressing is that what's referred to as the material validity section. And as I've pointed to, from 209 through to 232, he is actually engaging with the facts of the particular clauses.
He is.
Sorry.
He is engaging.
Yes, he is engaging. And that's why I say those sections which are essentially trying to draw on the general business conditions to expand the nature of the legal relationship are approaching it just the wrong way round from the point of view of the European law analysis. And so we say his conclusions there are wrong. But then he goes on, because he then is thinking in section H, which begins at paragraph 233. He then looks at the scope of the clauses under domestic law, which is the second stage that you have to carry out. Our appeal is about the errors in relation to the first stage. There is a second stage that has to be carried out under the scope of domestic law, where there's a consideration of, in particular, Swiss law.
But there's no issue on this subject, is there? Subject to
the
respondent's notice?
Yeah, under issue 3, exactly. But what I was going to say was, there's then that section H, and then you come to section I, which is then entitled The Applicability of Jurisdiction Agreements to PIF's Claims. And so...
Paragraph?
I'm so sorry, my lord, 284.
204?
284, I'm so sorry.
Yes.
Now, you might have thought that that section was just following on from the domestic law analysis under Swiss law, but it's not clear that the judge was just doing that in this section, because we see again as we work through references to materialising coming in, which is obviously the buzzword that he has drawn on from Apple sales. But you'll see there that what he does in relation to the applicability of jurisdiction agreements to PIF's claims is he actually, for instance, in relation to the Pictet Secret Commission claims, then highlights a number of the references to the pleadings about them. So one would expect at that point, one would have a clear analysis saying, and these disputes arose from a particular legal relationship. But if we just work our way through briefly this section, because as I say, we're dealing here with the applicability, and it looks, as I say, at the various articulations of the claims. But if you work through then to effectively 289, which is the conclusory, I think probably the key conclusion.
So this is the other part. This is the other point at which one might look to see how he deals with.
Yes, exactly. Sorry, this was I wasn't clear enough in my answer. That's precisely what I'm doing here. I'm going to the other place where one might seek to identify this. Now, I should stress, there's no analysis here of European case law going on.
Well, shall we just, for a moment, read?
Yes, please do, and I'll make some
see.
submissions on 289 when
Thank you.
we've reached that.
And which is he referring to here as between A, B and C?
It's A because you'll see the heading just above paragraph 284. It's Pictet Secret Commission claims. So I was focusing on A throughout in relation.
Yes.
And if you go down, in fact, to paragraph 317, you'll then see Pictet accessory claims.
Which are those?
Pictet accessory claims.
That's B.
B and yes, and C. I was going to come to that in a moment, but I was just focusing on.
Did you say 3, 1?
I'm so sorry, my lord. I was going to pick up just on 289 actually.
All right. Let's go back.
So
sorry, in fact, my lady's quite right. Pictet accessory claims here is our category C, actually. Yes.
Well, it's
Because
actually,
you can see
I
that
think it's
in the
B and
paragraph
C.
above. 316 is A and B. And
Well,
yes.
yes, albeit that the discussion that follows in relation to Pictet accessory claims actually does cover B and C.
Right.
So it's perhaps not as neatly delineated as one might hope in that regard, but I think.
All right. Well, now you wanted to make your point on 289
Yes,
before we go on.
So all I was saying in relation to this is there's obviously a long exposition of various of the characterizations of the claims, but I think they can all be summed up as being essentially directed at the secret commissions being paid by the banks to third parties and eventually, in the main, to Mr. Al-Rajaan and Mr. Al-Rajaan. And so none of this changes the analysis at all. But if we just pick up at 289, the judge summarises, on the basis of these allegations, it would appear that Bank Pictet and Pictet Europe had the better of the argument that these claims fall within the scope of the bank's respective exclusive jurisdiction clauses. The gist of the allegations is that by agreeing to pay and paying secret commissions to or for the benefit of Mr. Al-Rajaan, Bank Pictet and Pictet Europe induced him to cause PIFs to invest large sums with or through Bank Pictet and Pictet Europe, on which those entities earned substantial revenues, and that the secret commissions were at least in part funded by or referable to such revenues. In substance, they're the equivalent to allegations that contracts between PIFs and Bank Pictet, or the placing of investments pursuant to such contracts, were induced by bribery. Now, with respect, that's just not the case. That is not the claim that's being put here. The claim that is being put here is that certainly PIFs invested large sums. Certainly, it would be expected that the director of PIFs may well have directed the investments in particular directions to people, investment houses or through banks, where he thought that secret commission arrangements and laundering could occur. But we are not impugning the contracts, the investment contracts or the banking contracts that are in place here. That is not the essence of these claims at all. But more particularly, again, what we're not seeing here is any structured analysis of how these claims should be looked at through the prism of strict construction, the notion of consensus that we've seen in relation to the case law, or indeed the CDC analogy, because the CDC analogy applies in relation to these claims, where it can be said, look, what happened here was payment of secret commission by bank to third party. We are making a claim in relation to that, a civil claim. The fact that these investments were made by PIFs because Mr. Al-Rajaan plainly wanted them to be going to, amongst others, those that were paying secret commissions, does not mean that the contractual arrangements for the money going in somehow govern the terms of the secret commissions going out through money laundering and to Mr. Al-Rajaan, in very, very simple terms. And therefore, with respect, again, if this is the judge taking the analysis of the claims and trying to look at it through Article 23 glasses, he doesn't do it correctly. And indeed, in 289, he's plainly making an error in relation to the characterisation of the claims and the nature of the comparison that one should make.
Can you give a counterfactual in which fraudulent activity by one party would undoubtedly fall within an EJC.
Well, a counterfactual that actually referred to any fraud, which would be the analogy with the CDC express terms for competition claims, would be the closest. So if you had an EJC that covered explicitly any fraud or negligence on the part of...
Yes, but I mean, are you able to move away from that and say that if one just had a generic EJC?
I'll have to think about that. But I think the danger is...
Because otherwise many commercial disputes involve allegations of dishonesty.
Yes, of course.
So one has to know at what point, in a particular case, the line might be drawn to say that this is within, this is clearly without.
There are two things. One is I completely understand that the court may want the sense that one does draw a line somewhere. Indeed, however, it may well be that in the context of Article 23, it's not easy in all circumstances to draw bright lines in relation to these matters. But I'll give further thought to whether or not there are particular counterfactuals beyond the one that I've just given you in relation to an EJC covering fraud. But it will depend potentially on the nature of the way in which the fraud is committed, and in those circumstances, where if you don't have any third party involved, for example, the situation may be different. But I'm not going to commit to saying that that will necessarily fall within the terms of Article 23, because of course Article 23 is very concerned about the no surprise needs consensus, and in those circumstances it may well be that when you put on Article 23 glasses, in fact, many sorts of fraud do not fall within the scope of jurisdiction clauses, which if we were applying common law, we might look at differently. And that I must accept.
Can I ask you this, because I'll certainly be asking the respondents the same question. Why at paragraph 208 is the judge asking the question of whether the jurisdiction clauses relied on have been agreed in relation to a particular relationship, as opposed to whether or not the disputes? Why is he asking that question? Then provisionally to section H. That's certainly not the Article 23 question.
No, he's misstating the Article 23 question,
Yeah.
and then
and what he mean? Well, you would perhaps say not, but it may be said that what he is asking himself the right question in substance.
well, I'm not sure he is asking himself the right question in substance, because he's jumbled the...
That's why he may be focusing on the GBCs.
Yes.
In the following sections.
Exactly. Yes, that may well be the reason he ends up focusing on the GBCs, because he has not focused on the proper structure of analysis in relation to Article 23 and the language of the test that's been repeatedly articulated. But I think in relation to section H below, what he's then going on to talk about is the fact that there are two sets of conditions. One is the European law conditions, and then there's the question of the scope under domestic law. And so in the second part of that paragraph, he's doing something, he's referring to that, which we don't take issue with the idea that one has to do that as an additional. I think
it may be longhand or shorthand for the right point.
The latter part
it may explain why he takes the course that he does.
Yes. That may well be right, my lady. Yes, we can see that. But we say, unfortunately, that is an indication of him taking the wrong course in relation to the principal question in relation to European law. So, yes, and as I say, he then goes on to refer to H, and I was actually in section I, which is the applicability section. I've focused on the PICTE secret commission claims in relation to that. There is further consideration there of, as you'll see, reference to various other arguments that were deployed by PIFs in relation to these issues. But I'm not going to go through all of those. We don't agree with his conclusions on them, but they are not of the essence of the appeal issue that we are raising here, which pertains to European law interpretation. It is, however, perhaps just worth picking up when we do get down to 317, the Pictet accessories claims points, because here there is a discussion of what my lord referred to as B and C. One can see that, in fact, from 319, where the Pictet defendants argue that all of the laundering, so B and C, should all be within the exclusive jurisdiction clauses, which we say is plainly wrong. But you'll see at 320 that he articulates the difference, in his view, between B and C. Now we say, on any view, he's plainly right in his conclusions about C, even though we would say the position is a fortiori the conclusions of the judge, because if he applied the Article 23 analysis properly, C would have been absolutely obvious. But we also say that he's wrong in relation to B here. In other words, he's wrong to say that the laundering of secret commissions, the claims in relation to the laundering of secret commissions from the banks, so not from other investment houses, so B category, were agreed to be covered by the jurisdiction clauses when one's approaching this from an Article 23 perspective. We don't understand on what basis it can properly be said that the particular legal relationship also encompasses the construction, development and use of money laundering conduits, which actually occurred before the entry into the bank accounts. So we see from the chronologies that actually activity to put in place arrangements for laundering secret commissions was occurring back in 94, 95, before any of the bank accounts were entered into.
I mean, if you're right that there was confused thinking or some inappropriate approach, and you effectively then seek to persuade us that had the correct approach been taken, the result would have been different. To what extent do you need to take us to the intricacies of the pleaded claims, the wording of the EJCs and the like?
Well,
because we haven't done any.
No, well, I'm also conscious of the time. I was going to go through.
But is that part of the exercise?
Well, I'm not sure.
I
don't think it's going to be necessary to go to the EJCs are undoubtedly set out at the start of the judgment.
Yeah.
So they are in general terms. We don't have any issue with the terms that are set out and the selections that are in tabs 35, 36, and 37 of the.
Does it matter which ones apply, running through the passage of time?
No, I don't think it does. I don't think anything turns on it. I mean, some of the language refers to all relationships. Sometimes it refers to a legal relationship in the singular. And actually our point is that those sorts of nuances of difference in language don't make a fundamental difference to the way that you should be approaching this. You do not reverse in, effectively, the scope of general business conditions and say that constitutes the legal relationship.
So in a nutshell, on each of A, B and C, do you mind if I ask?
No, of course.
If you take the EJCs, you take the essence of your claim on A, B and C, and how do you say, looking at through your Article 23 lens, why does A, B and C not fall within the scope of the EJC?
Because the disputes that we are making claims in relation to, which are A, secret commissions paid by the banks to third parties, B, the laundering of those secret commissions paid by the banks to third parties, and C, the laundering of other third parties, secret commissions to third parties. All of those claims, or rather none of those claims, arise from the particular legal relationship that was instantiated by the opening of the one bank account with Mirabeau, even if you include the general business conditions, or the 96 accounts with Pictet through which multiple funds flowed or investments were
And what was that? What was the particular relationship, do you say, for Article 23 purposes?
Well, we don't try and characterise it in a snappy phrase because there's a danger that anything becomes well, it's an account holder.
So the particular relationship, you say,
it's a bank account holder in relation to these accounts. certainly with Mirabeau, it's in relation to custodian accounts. In relation to Pictet, it's predominantly custodian accounts, so bank and account holder. In relation to Pictet, there were certain fees paid to Pictet in relation to the accounts and in relation to some of the investments, but those were very limited. And in those circumstances, we say that it doesn't change the basic analysis of our being account holders.
So you say the particular legal relationship, both vis-a-vis Bank Pictet and your client and Bank Mirabeau, is bank account holder.
Yeah, and in relation to Pictet, there will be instances where we are also an investor with certain of the funds managed by Pictet. But that will be in relation to particular subsets. Your ladyship was asking about the details, and I'm just trying to capture the two types.
Yes. Well, I think I'm asking a fair question.
Oh, you're asking a perfectly fair question. I'm just avoiding giving an unduly generalised answer.
No. So bank account holder for Mirabeau on one account of account 500, whatever it was, and Bank Pictet, bank account holder, and specific instances of investment holder.
Yes. And so the real distinction is that even if you're thinking about us being an investor with Pictet in relation to various particular funds that go through some subset of the bank accounts, as I say, it's the money flowing into those investments in relation to which fees may be payable, which we accept. And as I say, we're not trying to unpick any of those investment relationships. What we're saying is what is done with fees and money subsequently is what is problematic here. And that's why we don't mind whether or not it's account holder or in relation to those specific instances an investment holder with the banks. But none of this gets us to the point where one can say that there is that there was consensus when those bank accounts were being opened and in relation to the subset investments made, that we were consensual in a jurisdiction clause applying in relation to matters that did not arise as disputes in relation to those bank accounts or investments. And that's the key test for Article 23.
Do you want to just briefly look at Section E of the judgment, where we've got a long list of contents of the jurisdiction agreements, just to settle your submission by reference to one or two of these?
Yes, well, as I say,
I appreciate you don't mince, well, you don't chop them up all up and so forth, but I just find it helpful to
certainly
to situate what it is that's
yes. So I'm always slightly concerned to start with Bank Pictet, since that's the one where there is an issue one about whether these terms came in, but
go somewhere else then.
But no, I'm very happy to just do it by illustration without prejudice to issue one, as it were. But if you look at paragraph 81 or 80, what is referred to there are general business conditions that were in use when PIFS opened its first bank account with Bank Pictet in 1998, and I've already made the point that money laundering arrangements were already being put in place. The standard form of account opening document included the statement, the account subject to the provisions of Swiss law and general business conditions. So that is undoubtedly true. When they signed the bank account opening, those words were there. There's an argument about whether those general business conditions...
Assume they're incorporated for this argument.
Yeah, for this argument we assume that. And then within those conditions, it said all bank-client relations are subject to Swiss law. Again, we don't have any dispute about that. The place of performance and place of prosecution for debts and exclusive jurisdiction for all proceedings of Geneva. But what we're saying is, yes, general business conditions will govern the client-bank relations that you have entered into. What we're saying is you enter into an account holder relationship or an investor relationship, but it doesn't mean that you're entering into any broader legal relationship with the bank in relation to, for instance, the consequence of what might happen in relation to dealings with third parties. In other words, the general business conditions are plainly wide enough to accommodate all sorts of legal relationships. But for the purposes of Article 23, what you have to identify is what the particular legal relationship was that gave rise to the disputes and claims. And we say it is plain that the particular legal relationship, whether it's account holder or investor, did not encompass anything wider. And that's why we say it doesn't matter which particular nuanced version of the general business conditions one is talking about here. And that's why we say that in relation to the end of section G, where these general business conditions are then referred to, we say that doesn't make the difference, because if you move on to 82, for example, because you've got this further version of the general business conditions, August 23, it says, Article 1 scope, these general business conditions shall govern the legal relationship between Pictet and the client. But you've got to ask yourself, what is that legal relationship?
It should govern all existing business relationships as well as new relationships.
Yes, yes. And what we're saying is, when we opened a bank account or invested with Pictet, we did enter into a relationship of that sort. And yes, the general business conditions will apply to that relationship, but those are the particular relationships that we're talking about here.
This is dangerous because one needs to make quite sure which bit of the exercise one is at, so I may be getting this wrong, but references, for example, to the legal relationship, not the contractual relationship, which you can see mentioned elsewhere. I mean, all those sorts of things. These are very fine points, aren't they?
Well, we say that the danger with saying there are fine points between legal relationship, contractual relationship, and so on in relation to these general business conditions is that one is in danger of losing sight of those broad points of proper construction as to what the particular legal relationship was for the purposes of Article 23, where we know we have to adopt a strict construction in relation to that. And we say that's why you have to look at it through European law glasses and not be in these circumstances, as the judge was, distracted by the nuances in differences in wording in relation to the general business conditions, because otherwise what you are in danger of doing is producing what is actually prohibited effectively under Article 23, which is an inordinately broad.
So do you say Bank, Pictet and PIFs had 96 different legal relationships?
We can see that each an account could be seen as a separate legal relationship. Equally, it makes no difference to us whether all of those accounts being opened and all of those investments are treated for these purposes as being governed as a single relationship. What it doesn't do is it doesn't bring in the other aspects, which are the aspects that are said to be part of a relationship between us and Pictet, when in fact they are concerned with the relationship between Pictet and third parties.
You really read, say Article 23 requires one to say that particular legal relationship means particular contractual relationship.
No, we don't go so far as to say that. We don't, and we couldn't go so far as to say it has to be a contractual relationship, because we recognise that in both CDC, but particularly in Apple sales, it's recognised that it can be a tortious relationship. But it's got to, or it can be a tortious claim that is brought in relation to the particular contractual relationship. It's difficult to envisage circumstances where there is not a core contractual relationship. That is true, my lady. And that is the essence of what is said in relation to CDC and Apple sales. Because, of course, in Apple sales, what was being considered was the distribution contractual arrangement and whether or not the tortious abuse materialised through that contractual relationship. So I don't want to say never, but certainly it is going to be focused around the contractual relationship in those circumstances. And of course, when we look at Etihad and the extension of the exclusive jurisdiction clause from one contract to another, of course, there's no doubt that the comfort letter we're talking about was also a contract in those circumstances. So, as I say, not only are these clauses referred to here, but just for the court's reference in tabs 35, 36 and 37, of the core bundle, I think it's core bundle volume 2, no, volume 3, I'm sorry, you have those...
They're probably more conveniently set out here, are they?
There is equally, it's equally conveniently set out.
I just wanted to see if I got to the bottom of what your submission amounts to. Are you saying that when one looks, for instance, at paragraph 82, where one has, I don't know whether that was the one you were looking at a moment ago, but it's similar, where you have scope and reserved matters in the August 2003 conditions, but it's just a matter of contractual construction. Leave aside Euro law. That approach, place of jurisdiction in Article 30, any dispute concerning the relationship between the bank, taking its colour from the fact that this is a banker-client relationship and that there are various general business conditions and there are various specifically reserved matters that are not to be covered by the GBC. That it can on no complexion be suggested that your clients were signing up to an exclusive jurisdiction clause if the counterparty was defrauding you.
Well, certainly defrauding us with a third party in the way that they did.
Right, so it's essential to your argument that it's defrauding with a third party, and in this case the third party is who? The manager.
Well, is the director and associates.
Director, sorry.
Yes. No, sorry, I wasn't meaning to correct you, my lord. But yes, it's the director, his wife, various associates, and so there are numerous people that are being sued.
So if, like Apple, you want to have an exclusive jurisdiction clause which includes the fact that you're going to have to sue me in such and such a place if I start defrauding you, then you've got to say so.
Well, that is certainly one of the counterfactuals. You asked whether there are others, and I said I'd think about it further, but that undoubtedly is the situation. And it's what is actually articulated in CDC, of course. And part of the reason why the Apple case came forward, because in CDC what is said is, if you want to capture competition claims against a cartel, you need to make it, you should make it explicit in your jurisdiction clause, because otherwise it doesn't fulfil the requirements.
Yes, but presumably, obviously, in general, trading organisations of that kind don't choose to put in an exclusive jurisdiction clause in the event that we defraud you.
That may well be right. I accept that, but that doesn't mean that the scope of Article 23 should...
No, but I mean, I just use that as a test of whether where this argument takes us.
Yes, well, I think it may, that may well be...
Because it seems to me that you are developing a sort of ex-terpi type argument, which may well be right, I don't know. But it isn't to be found, the root of it is not to be found in fine needlework.
No,
it's a very broad brush statement that we cannot be taken to have signed up to a clause which is premised on the fact that you're going to defraud us.
Yes, and that's what we say is being said in Estasi Salotti and Paldufrin and that interpretive chain of analysis. And it's why you do get the footnote from Professor Briggs in the end.
Right.
But am I right in thinking that you say that the logical analysis is you look at the claim,
yes,
look at the dispute, you look at the relationship, and you ask yourself first and foremost, is this Article 23 compliant?
Yes.
And you ignore the exclusive jurisdiction clauses altogether, their scope and all the rest of it. That's a matter of domestic law that may come in down the line. But the starting point is, what is the dispute? Is that right? Have I got that right?
Yes. I mean, obviously there has to be some colourable jurisdiction clause there.
Yes.
But yes, assuming you've got some reading of a document that has a jurisdiction clause in, yes, because those are the requirements of Article 23, and all we're saying is what is the legal test for fulfilling those requirements?
Or maybe I'm wrong. Or maybe I'm that if the parties if the parties have agreed that a court are to have jurisdiction to settle any disputes which have arisen, so there has to be a jurisdiction clause.
Yes.
You look at the clause to see what they've agreed to settle.
Yes.
And then is the order to look at the scope of the agreement and then see whether the disputes under the scope of the agreement have arisen in connection with a particular legal relationship?
Well, I completely take your point, my lady, that what you are ending up doing is crossing over between a definition of scope that's constrained by European law and a definition of scope that could further be constrained.
It's very difficult, isn't it? I mean, I'm expressing sympathy for the judge in terms of how to order the analysis.
I understand the point, but that doesn't alter the task that one has to fulfil. One has to fulfil the task of looking for whether or not there is an exclusive jurisdiction clause, and then looking at whether the disputes that are arising arise from the particular relationship in respect of which that jurisdiction clause has arisen.
Okay, so arise in connection with
Yes, yes. I'm so sorry. I was.
So if I have a professional relationship with somebody, if I go and see my lawyer or something like this, then whatever happens in terms of the advice and backwards and forwards, and me paying her or him, she or he giving me advice and so forth, that's the relationship between us. It's not if while I'm there I fall on the stairs or somebody takes my credit card out of my bag or something of that sort.
No, absolutely. That's absolutely right. That's what appears to be the sort of focal exercise that the European law approaches.
It would help me enormously if it's not the right time to ask you to do this, but if you could come back and give us a route map of what you say.
A rubric, yes.
The analysis ought to be in
Certainly.
by reference to some of the things that we've been teasing out, the overlap between scope and Article 23 and the particular relationship, I think, is quite a tricky issue. And I suspect, again, maybe asking for the same exercise on the other side.
Of course, and I'll happily do that. I mean, what I'm conscious of is if we go back to Professor Briggs' most recent book, he puts the analysis of these issues under the heading of scope,
Yes.
rather than earlier in relation to the conformity.
Playing around with a list of issues, you can do any one of a number of things, and I'm sure that you all did when you were trying to put it together. Where does something fit in? Where does something fit in?
Yes, and I think what we accept is that there are two roles here, and I think this, to this extent, there will be common ground that there is a European law analysis, and then there can be
A domestic law
a domestic law
There
analysis.
must be a domestic law
Yeah, and there's no dispute about
But
that.
EU law trumps
Yes.
the domestic analysis.
Well, because essentially, if your EU law says you don't have a jurisdiction clause that is applicable in relation to the particular disputes that you're
You
actually
can't go
talking,
forward.
you can't go forward.
You don't get to
You don't get to-
scope, but
you don't get to
so
stage two,
domestic
effectively.
scope if you've got over Article 23, you get to domestic
Yeah,
scope.
exactly.
And you may still come a cropper
Yeah,
under domestic law
That's
because
right.
the dispute doesn't fall within it.
that's exactly right. Yes,
Okay.
I mean and to that extent, I think there's probably common ground. But I think where the common ground does not lie is in relation to how one carries out the first exercise.
Yes.
So I'm very happy to take that away and think about it.
All right.
I'm also
Well,
conscious-
we've been engaging with this because it's an interesting point. But,
Yes.
just situate us. Are you going to seek to get to the end of this particular part of the appeal today? Is that a reasonable objective?
I can probably pause. I'll deal with the just very briefly further with the B and C that we were at.
Yes.
Very briefly on that, given time, and then I'll see whether or not there's actually anything substantive.
Right. Well, you can obviously hold things over, but it would obviously be quite
yes.
satisfactory if we were able to say we've basically heard you on this point.
I think that's right. I mean, because what I was going to do was very briefly finish on that.
Yes.
We've touched on the issues to do with what we say about the nuances of different general business conditions and so on. I'm not going to go back and revisit those. I'm not trying to work my way through all the pleadings. I recognise the passages pulled out by the judge, but I've tried to characterise our pleas in general terms so that you have the thrust of
Yeah, that's
them.
very helpful.
No doubt others will dispute my characterisation, but we'll deal with that in due course. So with that in mind, could I just go back to 320
Yes.
in the judgment, sorry, paragraph 320 in the judgment, just very briefly. So you'll recall this is under the section Pictet accessory claims. And I should say, just for speed, I'm not going to mirror everything in relation to the Mirabeau sections and so on, but the judge actually draws on his Pictet reasoning for the Mirabeau. So we say Mirabeau a fortiori in many ways because we only have one banking app, but leave that to one side. So in 320, what you see is the judge disagreeing with the Pictet defendant's attempts to suggest that the money laundering arrangements that were put in place in relation to the non-bank scheme money, so this is pure C, are plainly outside the scope of the exclusive jurisdiction clauses. And they say in their respondent's notice this is wrong, and they come back and set out various arguments. But I think, given time, I'll probably pick those up in reply insofar as it's necessary to do so. But we say those are flawed. What he does do is say, however, that in relation to B, he considers that there are, for example, issues of knowledge in relation to the money laundering in respect of the bank's secret commissions.
Well, are you reading 321?
Yeah, I'm sorry, I'm skating slightly fast through 320, 322.
Yes.
And then the allegations. It's actually probably easier if I just ask you to read down to 325. It's faster than me trying to...
Yes. Yes.
So he there is saying, look, there's a difference between the position in relation to B and C. We say he's absolutely right on C. Where he's gone wrong is in relation to B, whereas essentially he's saying, well, for instance, the contentions in relation to knowledge, for example, in relation to PICTE carrying out money laundering in relation to the secret commissions it was paying, are matters that mean that you should see those claims in relation to money laundering, the PICTE secret commissions, as all arising from the particular relationship, whatever that might be, that the EJCs govern. And we say that's just the wrong approach to looking at this.
This is the last sentences at page 434.
Yes.
The 4323. Thus, the knowledge allegations in relation to the accessory claims are closely linked and in part dependent on those in relation to the PICTE scheme. So
Precisely.
B goes in.
Exactly. And that seems to be core to his reasoning. And we say, well, look, issues to do with knowledge that may be ingredients of the claim just are not relevant to the question whether or not those disputes arise out of the relevant legal relationship. And I think it is worth, although my lady was perfectly fairly putting to me, what do you characterise the legal relationship? There is, as being, there is an ambiguity here in the judge's decision as to what the scope of the legal relationship is that he's actually defining. He seems to be just seeing it as broadly banker-client in very general terms. And at that point, there is a question arises as to how broadly he is drawing these terms, given, as I indicated by reference to the case law, the very broad drawing of essentially EJCs is deprecated in the case law in relation to Article 23. But in relation to this particular issue, we say, well, look, issues of knowledge and proof in respect of these claims, they're just not material to this. And it's the wrong approach that you're adopting in relation to including them. And they simply don't arise as an incident of the legal relationship for all the reasons we've given in relation to secret commissions, but a fortiori in relation to a structure of laundering arrangements using other companies, other bank accounts, and transmission through other jurisdictions, because there we're talking about the mechanism by which the money goes out. And we say that can't possibly be governed by this particular legal relationship. And just to stress, none of these monies that we're talking about, or the laundering, came through any of the bank accounts that were being opened. They were all through different bank accounts, Mr. Al-Rajaan's name, or front person's names, or front company names. They were not through any of the bank accounts that we're actually talking
Sorry,
about.
can you repeat that? Nothing?
None of the secret commissions or the laundering arrangements flowed through the bank accounts that we are talking about as engaging the exclusive jurisdiction.
Presumably that's part of the modus operandi.
Yes, yes, absolutely. Sorry, I wasn't meaning that this was... No, sorry.
No, exactly, but I mean, that's part of your case.
Yes, absolutely.
Of course
Sorry,
of
I'm
course
just
Of course they
re-emphasising it.
don't go through the bank accounts.
Of course. I'm sorry, I don't want to state the obvious, but it is obvious, but it's also important, because
Yes,
there is a
that's what
huge difference between the in and the out here. So I think at that point I can probably pause. I'll see whether or not there are other matters to pick up overnight.
But we were on ground
Issue 2.
issue 2, right? Material validity.
Yes.
And so, subject to anything that you'd like to say about that tomorrow,
Yeah.
we'll be moving on.
Yeah, I'll try and move on to issue 3 and issue 4, and I can undoubtedly deal with those more quickly than I've dealt with issue 2.
All right. I should stop there. All right. Well, we start at 10 o'clock.
I'm most grateful. Thank you.
Ladies and gentlemen, I'll just turn the live stream off, so I've got 90 seconds.